Welcome to today's video. I'm Rick Chapo with DMCA Agent Service.com. So today we're taking a look at the CASE Act, or as Homer Simpson might say, we're all going to die. The CASE Act is a copyright alternative and small claims enforcement act. It is a proposed federal law, and it is getting some attention because, of course, the word copyright gets everybody all fired up. Now, to understand what this act is about, we first have to understand kind of a problem, if you will, with current copyright law. So federal law on copyright is controlled by the Copyright Act. It sets forth, all the aspects of copyright that we would be concerned about. What is copyright? What is infringement? What are fair use defenses? And also, what are damages? And the way the damages are determined are undertaken in such a way that it makes enforcement actions for smaller claims very difficult to bring. And the problem is, let's say you have two photos that have been infringed on. Okay, realistically, your damage claims at a maximum, might produce damages of $60,000. Okay, and that's if everything goes pretty well. Now, what's the cost of actually bringing a copyright infringement lawsuit as far as legal fees? Well, you're probably looking at $60,000, $80,000, $100,000. So, are you going to go pay an attorney $60,000 to $100,000 to potentially recover $60,000 in a best case scenario? Probably not. And what about if it's a situation where maybe there's only one photo, and so the best potential outcome is $30,000? Well, you're going to go pay an attorney $60,000 to do that? Unlikely. Yes, I realize there's the principle of the matter, but when you start talking numbers, dollar numbers that have commas in them, a lot of people are going to be reticent to pursue that claim. So the Copyright Alternative and Small Claims Enforcement Act, the CASE Act, is designed to try to address that situation by creating what's called a Copyright Claims Board at the Copyright Office. And this claims board would be its own department, and the Copyright Office would hire 3 permanent full-time lawyers to essentially act as small claims judges. And these lawyers would obviously be versed in copyright law. They would be specialists in the area. So unlike when you go to regular court or traditional court, you would have somebody, in this case, who really understands copyright law inside and out. Now, this would not actually be a traditional copyright trial. So you wouldn't have a copyright owner file a formal complaint, and a defendant answer with a formal complaint and discovery and everything else. There would be aspects of that. But in this case, it would be kind of more like what you see on TV with like the People's Court or Judge Judy and things like that. Now, there wouldn't be the yelling and screaming or any of that. But the judge, the IP attorney, would actually work to try to get the parties to understand whether their cases, their particular positions were valid or not, and try to, push through a settlement of sort. If that couldn't be reached, then the IP attorney could issue an award. Now, the award for a single infringement, the maximum award would be $15,000. And no matter how many infringing acts there were that were at issue, the maximum the attorney could award in the case would be $30,000. So again, we're talking kind of like a small claims situation here that you see in state courts. In state courts, usually the limits are $5,000 to $10,000, depending on the state. But it's the same kind of an idea. And what they're trying to do is create an environment where smaller infringement actions, alleged infringement actions, can be dealt with. Now, the CASE Act has caused quite the uproar because it contains 2 things: 1, copyright, and 2, a political decision, which in our society today both get everybody all fired up. And the critics kind of come at it from everywhere. I don't really see many of the criticisms having much validity. One of the first things to understand about the CASE Act is that the Copyright Alternative and Small Claims Enforcement Act it's voluntary. So if you're a copyright owner, you don't have to pursue this particular channel to enforce your copyright. You can still go file a federal lawsuit instead. So this doesn't change anything for you. If anything, it's just going to help you by hopefully streamlining the process. So if you only have one small infringement matter or 2, you can pursue it. Now, free speech advocates say, well, yeah, but copyright trolls are going to abuse this system. And it sounds right at first glance, but when you really think about it, again, I think the claim's kind of weak. First of all, the IP attorneys who are going to hear these cases they're copyright attorneys. They understand how copyright works, particularly with the internet now and everything. They're going to understand what trolls are, and they're not going to be awarding damages to trolls. They're just not, because that would completely defeat the entire system and the purpose of the system. I just find it hard to believe that the copyright attorneys that are hired by the Copyright Office are going to show any empathy for trolls. Secondary, and perhaps even more important, this is a voluntary situation. So if a copyright owner files a complaint with the Copyright Claims Board is then going to send a letter to the defendant, the alleged defendant, saying, hey, there's some allegations filed against you. At that point, the defendant can opt out, can say, I don't want to go forward with this. I do not submit to the Copyright Claims Board. If this guy wants to sue me for copyright infringement in federal court, go for it. Now, that may sound kind of aggressive, but that puts you back in the position where you are today if the Case Act doesn't exist. If a copyright infringement claim is being made against you, well, the proper course of action now is to go file a copyright infringement claim lawsuit in federal court. And so if you opt out of the Copyright Claims Board action, well, then there you go. You're in the same position as you would be in now. So, is the Case Act perfect? No, not even remotely. Is small claims court perfect in states? No, not even remotely. But it's an effort to try to create, a potential solution that would work for a lot of parties. And so I don't personally have that big of a deal with it. Now we are obviously in a situation now where the political process in Washington, D.C. is slightly a mess. So what chances are that the Case Act will pass? Well, it's already passed the House, and the vote was 410-6. And the vote is important because it tells you that's a bipartisan vote. Yes. We want to talk a miracle. It's a Christmas miracle. Republicans and Democrats agreed on something. 410-6 suggests there isn't any kind of political divide on this. So one would think that when it gets to the Senate, that it will also pass, and perhaps President Trump, if he's still president, will sign it into law. Now, of course, we're talking about Washington, D.C. and political parties. So who knows? Somebody, may come up with some random objection nobody's thought about, and it all, goes down a big old ball of flames. But generally speaking, right now, it looks like the Case Act will pass. So anyways, that's kind of what you need to know about it. When it does pass and you start seeing all the clickbait posts about we're all going to die and everything else, understand that's probably not really the case. You might actually even go read the Case Act. It's not particularly long, and it's not particularly difficult to read. And you'll see that it is not the end of the world. So with that in mind, I hope you enjoyed the video. Thanks for watching. Have a good one.